Welcome to Looking at Legal Stuff. Today we have 4 hearings during the divorce of a couple where the husband is seeking a PPO against his soon-to-be ex-wife, claiming she is making threatening phone calls to him and his girlfriend, sending him mail, coming to his place of business, and stealing his truck. The wife says none of that is true. In fact, she has a PPO against him, and he's the one who threatens and abuses her. She says the truck actually belonged to her parents and was still in their name, and that the mail that she sent him was a response to his divorce papers. In the new updates, we have a show cause hearing where the wife, who doesn't seem entirely sober, tries to convince the judge that he has broken her PPO by calling her and harassing her on 4 different occasions. But this time the husband has hired a lawyer to help him prove that she is lying about everything. He claims he wants nothing to do with her, and he motions the court to drop her restraining order so that she can't keep trying to use it against him. Let's see what the judge thinks.
I can hear you. Give me one moment here and I'll call us into session. The 37th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding. It is Monday, March 18, 2024 at 11 a.m. 2 cases for these parties, 2024-391 PP, John McKediak versus Lindsay McKediak, and 2024-113 PP, Lindsay McKediak versus John McKediak.
Okay. Good morning to both of you.
All right.
Court will note that in the 391 PP case involving Mr. McKediak, he's filed a petition for a personal protective order. And in the other case, the 113 PP, Ms. McKediak has filed a motion to show cause for violation of the PPO. Ms. McKediak, I'll let you know, your proof of service shows service on the respondent on March 14, 2024, which was last Thursday. That is improper service. So I cannot take up your motion to show cause on today's date.
Okay.
So the only issue the court will be addressing today is the petition in the 391 PP case. So Mr. McKediak, in this matter, will proceed on your petition. Do you wish to render any testimony?
I mean, no, other than what was stated in the PPO.
Well, you're gonna have to enter some testimony because I won't do it just on a written statement. So what we're gonna do is have you sworn in, raise your right hand, be sworn, and then we will proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Okay. Go ahead, sir. Tell us what you'd like us to be aware of. What happened that you should be getting a personal protective order?
So we've been separated. She's came to my place of business, unlawfully removed vehicles.
Okay, hold on a second. When you say she, obviously
Lindsay,
she doesn't mean anything. You have to tell me who she is.
okay, I apologize. Lindsay McKediak had came to my place of business and removed vehicles. She has pending cases for that. From my understanding, Lindsay McKediak also has another PPO placed on her by somebody else. And Lindsay McKediak still has possession of her firearms and continually calls me, threatens to shoot me, threatens just continually harassing me and harassment. And then, you know, she feels she needs a PPO because she's scared of me, but she's coming to my house, driving by, calling my phone all the time by block numbers, no caller ID numbers, and threatening friends and associates. And I'd like to say or show and sending mail to my house that says happy birthday, hubby, love you, with balloons and hearts.
Okay.
With her name written on the front of it.
Okay.
And she has a PPO on me, but she continually violates it. So I feel like I need to protect myself from her feeling like I have no recourse because she can do whatever because she has a PPO on me.
Okay, you stated that there were various dates that she called and threatened you and things of that nature. Do you have dates for that, sir?
Yeah, it was, I want to say February 9th or 11th.
Okay, and what does it pertain to? Because you made a lot of allegations, so I need to know if it was, you say what date, what was the date again?
I want to say February 9th.
Okay, February 9th. What happened on February 9th?
I had received a bunch of no caller ID calls, and I wouldn't answer
Okay, how did you know it was her if you have no caller ID on that?
because my girlfriend had answered the phone and had her on speaker, and they commenced to argue and threatening each other. And
Okay,
Lindsay threatening her.
so did you hear the conversation when they were on the speakerphone?
Yes, I was in the vehicle when she answered it, and it was on my phone.
Oh, okay.
And also,
Hold on. There's a
Sorry.
lot of things we have to establish. You just can't.
Okay.
Well, did you recognize respondent's voice on the phone?
Yes.
And what did she specifically say to you? I'm not concerned about what she said about your girlfriend because she's not a party to this. So what did she say to you or make any threats to you?
The typical, if I come around, she's going to shoot me, that she's going to make sure I lose my business. She takes half of it in the divorce because I filed the divorce on her. And also numerous times of stealing my dogs and selling them, which she has in the past.
Did she threaten that or you're just bringing that up now?
No, she said that. Like, let your dogs be outside running loose and they'll come up missing again and blah, blah, blah.
Okay,
just,
so she threatened to steal your dogs.
yes. And I have numerous text messages from her threatening to have me locked up again. I'm going to go away forever. Just repeatedly over and over. And then also, you know, I've had to have her removed from the shop by BCPD to where they told her if she come back on the property, she'd be arrested for trespassing.
So crazy.
And threatening that if I didn't pay the child support when she wanted, she'd have me locked up. There's numerous calls to Tom Mize, which was my federal supervised release officer, where she called and threatened him and his supervisors to do something about me and when I pay my child support, and trying to turn in evidence to have me incarcerated again.
Okay.
For violating no contact.
Now, on the letters that you claim were delivered to you, when were the dates of those?
This one was March 1st, 2024. And I have the picture of it. It's in her handwriting. Well, this is the actual envelope. This is the handwriting. And then this is also her handwriting and her little messages at the top, whether to cause problems between me and my now girlfriend or just antagonize and upset me.
Okay. And any other dates that you've gotten those letters?
No,
Okay.
that was the most recent.
So effectively, if I'm correct, is that you've received numerous phone calls, you've had visits at work and letters in this particular matter. Is that correct?
Yeah. Yes. Well, and also her unlawfully driving off with the vehicle that I was in possession with.
Well, that's for another matter. That's going to have to be something that's resolved through the divorce action.
Oh, yeah.
Okay.
Well, she was charged with that.
Okay. Okay. Anything else, sir?
Well, Your Honor, I wasn't in the state the date of the issue of the original PPO.
Okay, we're not addressing that today, sir.
Okay. Okay.
There's nothing in your petition. You didn't file a motion to terminate their PPO, so I can't take that up today.
Oh, okay.
Okay, Ms. McKediak, I'll have you raise your right hand and be sworn in, and we'll take testimony from you if you wish to give any.
Yes, sir.
Ma'am, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Ma'am, I'll first advise you in this matter with what's been stated, only because there's a lot of things that have been stated. I want to make sure you understand that you have a Fifth Amendment right against self-incrimination, and you don't have to answer any questions that may incriminate you for any criminal proceedings. You understand that?
Yes, sir.
Okay. And I don't know if they'll come up. I'm just mentioning it because of what he's alleged. I don't want you to do anything that's going to have an adverse effect on you that you should not admit to.
Thank you.
Okay?
Thank you.
As to the allegations that he's made, have there been phone calls made in which you have threatened the petitioner?
No, Your Honor. No. Your Honor, I do not have time to threaten.
What he's saying is that, again, in the phone call, that he recognized your voice on 2-9, that you threatened if he comes around, you're going to shoot him. Did you
No.
say that?
No, sir.
Did you threaten to steal his dogs?
No, I do not.
Did
lock
you
his-
threaten to have him locked up?
No, sir, but there was a no contact order on his federal
Okay, that's not what I'm asking about, ma'am. Don't go
No,
off on tangents and stuff I'm not asking. You can bring that up
No,
later.
no.
Did you threaten that you were going to have him removed from various jobs?
No, Your Honor.
Did you send him a handwritten letter on March 1, 2024?
That envelope is a service of my response to the divorce, and I did not write the message on the back, but that's a
Okay.
service for divorce. So, in which I have the proof of service and I have my response right here, and in which it was filed and mailed to him in the envelope. And that is what that is. That is not a letter. That is the response to his divorce.
Okay. Did you, in fact, as he stated, go to the property where he was working and remove a vehicle that was in his possession?
No, that vehicle is my parents' truck.
Okay. Anything else, ma'am, that you would like to say in response to the
It's
allegation?
just I don't threaten him, and on these dates of February 9th, February 8th, of the dog matter, of any of his girlfriend calls me, he threatens me. This is ongoing and scary, and very scary on the part of I don't have time to threaten John. There was a no contact order with his federal.
Again, ma'am, that's not a part of today's hearing, so I don't care about what happens on his probation.
Well, what I'm saying is that there's no contact.
And I'm telling you, I don't care about what a different proceeding is. That's not involved in today's hearing.
POs, no contact orders.
Ma'am, you're not listening to me or something, because I'm saying I don't care what's happened in his other criminal action, okay? If he has a no contact order or not, it doesn't pertain to this proceeding. He is seeking to get a PPO. So anything that's happened in some other action, I don't care about.
I'm saying I've taken the measures to protect myself and get PPO orders. So that way I'm not contacting him. I am not threatening him.
Okay. Anything else, ma'am?
I do not write him. I do not call him. I do not have time. I have an autistic son that I take care of, and I am constantly being threatened. I am constant, and I try to cover my butt with
Okay.
this. I
Okay,
call
thank
him
you.
in courts. So
Sir, do you have any other witnesses or evidence to present?
No, pretty much just that envelope. You know, she filled out the front, the heart on it next to her name is the exact same hearts that are on the back of the message that she said she did not put on there.
Okay.
If I also need to drop off, I can print out all the threatening text messages she has sent from her actual number that has her photo on it to the courts if you need that for more evidence. And you can look up the police proceedings from her removing that vehicle that I was in possession of from my business.
Just to confirm, sir, was that vehicle, was it in fact her parents' vehicle?
No, they had sold it to my little brother. And then my little brother went to jail and I was using it waiting on my new vehicle. And
it is still titled to my parents.
Ma'am, don't interrupt. I didn't go to you yet, so be quiet when you're not asked to talk.
There is a police report and there is a criminal case against her for removing that her dad had pressed charges on her because she didn't have authority to go and remove that vehicle. And her dad returned it back to my shop after dealing with the state police at her house and taking it from
so
her.
the vehicle was returned.
Yes.
Okay. Anything else, sir, before we conclude?
No, sir.
Do you wish to make any closing argument?
No, sir.
Okay. Ma'am, is there anything else you would like to say before we conclude?
That vehicle is still titled in my parents' name. And this is all to get my CPL taken from me. So, and he threatens that constantly because this man has taped me up. He has came into my home. He has beat me, abused me, tried to kill me. And that's why I have PBO orders. I am so tired. I'm tired because I raised 2 children. And I am tired of these. I don't have time for these games. And he is doing this because if there's a PBO placed on me, then I cannot protect myself, and he knows that.
Okay. Well, in this matter, the court has heard the testimony. I would state in this particular case that, again, when the court does listen to testimony, the court notes that credibility is always an issue. Oftentimes, parties will allege that another party has lied or given false testimony. However, the court's found that conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, or misunderstanding, that it does inconsistencies do not always determine or denote that a party has lied. It can simply be a matter of perception. Obviously, there's some inconsistencies here. The court, in deciding whether to grant a personal protective order, I can grant a personal protective order pursuant to the sections on personal protective orders, which is MCL 600.2950. And specifically, the court can grant a action enjoining or restraining a person if there is reasonable cause to believe that the individual has committed or may commit any of the acts listed under MCL 600.2950 parens 1 parens A through K in this particular matter. What happens is, after listening to the testimony, the court does believe that there's reasonable cause to believe that, again, that the respondent committed or may commit any of those particular acts. The petitioner stated that there was a call on February 9, 2024, in which some threats were made, that there was a letter on March 1, 2024 that had some handwritten statements on it. The court will note that also the respondent did remove a vehicle from the petitioner's possession, which was subsequently returned to his possession. The court will note that the respondent has stated that she did not threaten him, etc. in this matter, that in fact she didn't write on that envelope, but the court does believe that there's sufficient evidence to believe that, again, not only that she may have committed, but may commit. So the court is going to enter a personal protective order, which would prohibit the respondent from assaulting, attacking, beating, molesting, or wounding petitioner. Also, that, again, would keep her from appearing at petitioner's workplace or residence, or sending mail to him, or contacting him by phone in this particular matter, or from threatening to kill or injure him in any way. The court will not enter an order which would prohibit her from possessing a firearm, and the court will keep this in place for a period of 1 year that will allow you to get past the period of time of your divorce action. Hopefully things can settle down at that particular point. So that will be the order of the court. We'll do that, and then that's how we'll proceed.
I think you.
And that will conclude the matter. And Mr. Pediac, you can come down to the court, and the PPO coordinator, and she'll assist you in getting a copy of that, et cetera. Okay?
Yes, I appreciate it. Thank you.
Thank you. You're free to go. Have a good day.
You too.
All right. Is this Lindsay McKediac on the 0223?
Yes.
Okay, we'll just have you here via telephone. Give me 1 moment here. Yeah, your video was not working there.
I had the video turned off because my kid was running around near my computer, so I just had.
That's fine. We'll just proceed this way. Okay, so thank you for your patience. So this is now case 2024 384DM. John McKediac versus Lindsay McKediac. It is Wednesday, March 20, 2024 at 8:40 a.m. Defendant is here via telephone.
Okay. Good morning to both of you.
Good morning.
What it is, this is a scheduling conference, and the court will put in place various dates as well as various processes so that the case proceeds in an orderly fashion. I will go to the plaintiff first, then I will go to defendant, and we'll kind of go that way as we go through. And at the time that this is done, then you will get a case scheduling order, which will set forth everything that we're talking about today. I'll ask you, Mr. McKediac, what issues do you believe to be in dispute in this case?
I mean, as far as
Well,
like
custody, support, parenting time,
Yeah,
property division, spousal support, or other.
yeah, I don't really want anything but the judge to redo the visitation so I can see my son. I pay my child support. All the money I've invested into the relationship or our house or whatever. I don't want a part of the house. I just want to be able to see my son
Okay.
without her controlling the matter.
Okay. So I'll put down, based on what you said, Mr. McKediac, that parenting time is the only issue that you believe to be in dispute.
Correct.
Okay. Ms. McKediac, what issues do you believe to be in dispute?
He has financially abused me.
He has what?
Financially abused me throughout
Okay.
the whole marriage.
Okay, I've never heard that. How would that happen?
Destroyed all mine and my child's stuff, selling all my stuff, making it so I only have $12 to my name.
Okay.
Take my
So
money.
with that, ma'am, what do you believe to be the disputes then? Is there property division? Is there spousal support dispute?
Yes,
Okay. I will put that down.
and to protect my child from being anywhere near him.
Okay. There is a process whereby you can get information from the other side, and that's called discovery, where you can serve the other party with interrogatories, requests for production of documents. You can have depositions, etc. Mr. McKediac, are you anticipating any discovery?
I mean, no, she doesn't. I don't see her hiring a lawyer. If she ends up getting a lawyer, and dragging it out, then I'll retain counsel myself. And then we can go the rougher route. You know, she's trying to replace material that was already replaced when I redid the house.
Okay. What I'm gonna do, because the case is early on, I'm gonna give you until June 1 to do discovery. Okay, so that means anything that you have that you want to get from the other side as far as information, you have to do that before June 1. I'm not going to, again, extend that because you have enough time to do it. So make sure it gets done before that time.
Okay.
What I'll do is that will put June as the mediation month where you will meet with an attorney mediator. There is a cost associated with that because they don't work for free. And I'll ask you, Mr. McKediak, do you have anybody you recommend as a mediator in this case?
No, I don't yet.
Okay. Ms. McKediak, do you have a recommended attorney mediator?
And do I have an attorney?
No. Do you have someone that you recommend or that you'd like as a mediator?
What, I don't understand, I guess, what that means.
Okay. What'll happen is, being that the two of you have not designated a mediator, the mediation clerk will randomly assign an individual to serve as the mediator.
A mediator for what, though?
Excuse me?
A mediator for what? I guess I'm.
Well, you said that there are issues of property and spousal support, and Mr. McKediak said child or parenting time. So what happens is the mediator will meet with you and attempt to come to a resolution of the case after having met with you.
Okay.
And then at that point, if there is a resolution, the mediator will take that and, record or prepare it and have it signed, et cetera. And then that will conclude, if you resolve all the issues, then that concludes the case other than the final paperwork. If not, then again, we have to do some more.
Okay.
What's going to happen is we're going to be sending out this case scheduling order. I will tell you both, pay attention to what's in the case scheduling order because there are various dates in that order. And if you don't comply with those dates, it could have an adverse effect upon your case. For instance, there's dates in there as to when you have to exchange exhibits. There's dates in there in which you have to exchange a witness list, et cetera, that you have to exchange a property division chart. And if you don't do that, again, that could jeopardize your case as we go forward. So make sure that you pay attention to that when you get that and do what you need to do. Okay?
Yes.
Mr. McKediak, do you have any questions?
No, sir.
Okay. Ms. McKediak, do you have any questions?
Not at the moment. No.
Okay. You'll get this order sometime, probably the end of the week. And as I state, make sure that you pay attention to that and that you comply with all of the dates in there, just so that you don't impede your case or create any problems as we go forward. So that will be the order.
Date for the settlement conference.
Oh, yeah. I have set the settlement conference in this matter for July 8, 2024 at 1:30 p.m. If you don't settle at mediation, you will have to be present at that settlement conference. Well, you have to be present at the settlement conference in any event, but we may be able to get taken care of before that if we do have resolution at settlement. At the mediation. Okay, thank you. That'll go out in the mail.
July 8th at what time?
Excuse me?
July 8th at what time, sir?
The time of the July 8th.
Oh, it's 1:30 on July 8th.
And what is that date?
July
Maybe-
8th.
Yes, what is that for?
That's a settlement conference, so that we
Settlement.
can,
Okay,
yep, and that date's it's in the order, so you'll be able to see it in there.
okay.
Okay? Thank you. You're free to go. Have a good day.
You too. Thank you,
Thank
sir.
Please unmute Ms. McKidiak.
Yes, can you hear me?
Yes, we can hear you now. Okay, thank you, everybody, for your patience. This is for two cases, 2024-113 PP, Lindsay McKidiak versus John McKidiak, and 2024-391 PP, John McKidiak versus Lindsay McKidiak. It is Monday, June 10th, 2024 at 11:16 a.m. Attorney Shelley Hoffman for the respondent, Mr. McKidiak in the show cause matter.
Okay? We'll take that matter first because Ms. Huffman is here and you only, just for purpose of the record, Ms. Huffman, you do not represent the respondent in the motion to terminate. Is that accurate?
That is correct.
Okay. Okay, so Ms. McKidiak, you filed the motion to show cause. You can proceed. Would you like to make an opening statement or simply proceed to your proofs?
Just proceed.
And you're going to have to speak up so we can hear you.
No, I don't need to make an opening statement.
Okay. Ms. Huffman, do you wish to make an opening statement or proceed to proofs?
I will waive opening.
Okay, thank you. Ms. McKidiak, you can proceed and present any evidence that you wish. If you are going to testify, you're going to need to be sworn in. Do you wish to testify?
Yes, I guess. I don't understand the difference of.
Well, when you file a petition, all there are is allegations. That's not evidence. It's just allegations.
Okay.
If you are going to want to have that be evidence, you're going to have to testify to that. So that's what I'm asking you. Do you want to testify or you don't want to testify?
No, I guess no.
If you don't want to testify, then the court's going to dismiss your petition because there'll be no evidence for the court to make a determination on.
Oh, okay. Well, then I guess I have to be sworn in.
Speak up, please.
I said, then yes, I have to be sworn in.
Okay. Ma'am, what we'll do is we'll have you raise your right hand and we'll have you sworn in and then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Go ahead, Ms. McKidiak, you can testify.
Okay. Well, he just calls me when he's drunk and threatens me and threatens my children. And he said that he's gonna bury me. And then he's mad about the PPO. So he that I filed in the first place. So he said he was going to get a PPO, and he's recently, which.
Okay, ma'am, just clarify, just so we know, because you made various allegations. I don't want general statements. If he contacted you, give us the date and the time when he contacted you as to each time.
Okay, March 18th. In January 20.
Okay, are we talking 2024?
2024, February 7th, February 11th.
Okay, let's take them one at a time, so then we can get the evidence. So you mentioned the 3/18/2024 first. Let us know what happened on that date.
He called me and told me to go kill myself.
Okay, anything else on that date?
He called me a clown due to the fact that he thought that the PPOs have gotten dropped. from the last court date. He called me off of somebody else's phone, so I answered off of.
Okay, again, what date did he call and what did he say?
That was the date in which I'm telling you that he called me a clown and to kill myself.
On the 18th, on March 18th, 2024. Okay.
Yeah.
Anything else that happened on that date?
No.
Okay, what's the next date that we're talking about?
Believe well, so go backwards to February.
February what?
February 7th,
Is that 2024?
2024.
Okay. What happened?
He called me and he said that, he was going to take everything in divorce. I was going to have to live in a box. He says that he'll pour acid all over me so that way I'll never look good for another man and no one will ever want me. And then he's going to make sure me and my kids have nothing. He does this when he gets intoxicated. So it's normally when he does it. When he's not been drinking, then he's usually, well, I don't get any, we don't contact each other, but when he's not been drinking, then
Okay, all that I don't need to know. I just need to know what happened on what dates.
okay.
What happened? What are any other dates that you have?
Yeah, it's February 11th. He was in Florida.
Again, is that 2024?
2024.
Okay. What was said?
Just the same thing. Name calling me junkie loser. And he said that he's gonna have someone come kill me. And he's in another state, so it won't be him, and that he'll get the kids, and just a bunch of nonsense, really.
Okay. Anything else?
No.
Okay. Any other dates that the court has to be concerned about?
Well, I hate having to do this. The other day he called my mother saying that he was going to.
Okay, ma'am, I'm not concerned about him talking to any other third parties. The PP only keeps him from contacting you. So
Right.
he
But
can
it
talk
was
to,
correct.
hold on, ma'am, don't interrupt me. I'm trying to explain this to you.
Okay.
He can only prohibited from speaking to you. He can speak to any other third party in the world that he wants to. So I'm only interested about when he's contacted you.
Okay. Guess the only reason I brought it up because it was a threat.
Okay, you've addressed the March 18th, 2024, February 7th, 2024, and I think February 11th, 2024. Is that the extent of it?
I mean, yeah, there's been other dates, but yeah, that's.
Okay, because I'm the court will make a determination based upon those dates once we're through. I want to make sure that you have covered everything that you need to.
Well, just one, that was back in January too.
Okay, what date in January?
January 27th, 2024.
27th?
Yes.
Okay, what happened?
Him and his girlfriend called me and told me to get my ducks in a row.
Hold on, you said his girlfriend called you or he called you?
Him and his girlfriend.
Excuse me?
Him and his girlfriend.
Okay, go ahead.
And told me to get my ducks in a row because it was after I filed and he had been served with the PPO, and he was angry about it. So they were threatening me that he was going to file a PPO back. And
Okay, I'm not, when you say them, I'm not concerned about what the girlfriend said. I'm only concerned about what he said, because as I told you just a moment ago, I'm only concerned about any communication he has with you.
I'm telling you what he said.
Excuse me?
I'm telling you what he said.
No, you said they said, and I said, I don't care what the girlfriend said. I'm only concerned about what he said.
Okay, well, I guess I meant when he said them, like that they were going to, this is what he said.
Okay, go ahead.
That they were going to, like, that's what I mean by that they were going to file for PPO and that they were going to file for divorce and that they were going to get the kids. And so the PPO then which I was served is in his girlfriend's handwriting, and so was the divorce then which that he had filed was in his girlfriend's handwriting.
Okay, anything else?
No.
That's all the testimony that you have to give. Is that correct, Ms. McKediak?
Yeah.
Okay. Ms. Huffman, any cross-examination?
Yes, so, you indicated that on February 11th, he contacted you and was in Florida. How do you know where he was at?
Because it was a FaceTime call.
It was a FaceTime call,
Yes.
and so you could see Florida in the background?
I could see he told me it was in Florida.
Okay, ma'am, keep your voice up because it's hard to hear you. And I'm only saying that because you can answer and say what you want, but if I can't hear it, I can't consider it, okay?
And you said that was the date that he made a threat to you that he was going to kill you, but it wouldn't be him, it would be someone else. Is that right?
Yes.
Do you have, oh, scratch that. What time did he call you that day?
And it was in the afternoon. My phone broke, so I wasn't able to get like I don't have like a screenshot or nothing because my iPhone broke.
Okay, so I don't have Facebook or I don't FaceTime or anything like that. So you'll have to explain to me, why is that information not available just on Facebook and only on your phone?
I guess I don't understand the question that you're asking, but I no longer have a phone
But-
or any of that.
Okay,
So
what I'm asking is that isn't Facebook like a cloud-based messaging service or app service or something like that? Facebook, it's out in the cloud, right?
yeah, but if it can be, but if I can't log into it anymore because the phone broke, then and I had deleted Facebook. So after everything.
Okay, so you could access it from a computer, but you just deleted it, right?
No, because it sends a link to the cell phone. It'll send like a code to the phone. If the phone that is on doesn't work no more and everything, I couldn't access it. No.
Okay, on March 18th, what time did he call you?
He called me at night.
Like,
So that was probably like 2, 3 in the morning. Because he calls me when he's drunk.
and February 7th, what time did he call you?
That was at 2. I remember that one specifically being 2:22 in the afternoon because I was taking my friend to work. So I do remember that specifically being 2:22 in the afternoon.
And you were taking your friend to work, you were driving
Yep,
and FaceTiming him at the same time?
that wasn't a FaceTime call, and I can answer with my steering wheel. And it was called over a private number, so I just answered the phone.
Okay, which date did you say was at 2:22 in the afternoon?
February 7th, when he said he was going to put acid all over me, and I never looked good for another man ever again. And he was mad because I was giving my friend a ride to work, and then he was going to divorce me and take everything from me. And
On January 27th, you indicated that they were going to file a divorce and they were going to do specific things. Who contacted you? Was it Mr. McKediak or his girlfriend?
it was both of them. I mean, it was out of his phone, but it was both of them.
It was what?
Both of them.
But what did you say before that? It was off of what?
His phone?
It was from his phone?
I believe so.
Okay, and were all of these calls off of his phone?
Not all of them, no.
Were most of them from his phone?
One of them I know for sure was off his phone. But that one, I believe, was off of his phone.
I can't hear you, ma'am.
That one, I believe, was off of his phone.
Okay, January 27th was off of his phone.
Yes.
Is there any other ones that was off of his phone?
I don't know if they're off his phone or not because they were private calls, or sometimes they were. It doesn't mean it wasn't off of his phone. It could, like, if it was private phone calls or off of somebody else's Facebook. It doesn't mean that it wasn't off of his phone.
You indicated that on March 18th, I believe you said that he called you from a different, one of these dates he called you from a different number. Do you have that phone number?
No, I don't have the phone no more.
Okay,
My phone broke. I had to get a new phone. I don't have the phone no more.
okay, so when did you write this this
But I-
motion?
Sorry.
When did you write this motion with all of these dates on it as to what was said?
I wrote it back in March.
And how did you remember what was said on January 27th or specifically January 29th or any specific date?
Because I wrote it down. My phone broke after I filled like this out, but I wasn't expecting my phone to break.
I'm sorry, I didn't understand any of that.
I wrote things down, but I didn't like expect my phone to break. Where I had things saved and it didn't iCloud like storage, and so. But I can tell you whose phone I know whose phone he called me off of. I don't know the number, but I know whose phone it was. Like a lot of time, like, do you know people's numbers? Like we store people's numbers in our phone. I don't know nobody's number, but if it comes up somebody's name in my phone, okay, I know their name.
Okay, that's all. Thank you. I have no further questions.
Ms. McKediak, I note when you were giving cross examination that you said you believe that the calls were from his phone. And what leads you to believe that they were from his phone?
Well,
And speak up, please.
so because it was him. And
What was that? I couldn't hear you.
Because it was him, he called me off of his phone. I would believe it would be his phone.
Okay, well, that doesn't help me. I just want to know how you're saying he called you and you believe it was his phone. And you said you believe it was his phone because he called you. Hold on. You said you believe it was his phone because he called you. Well, somebody could have another phone and call you. I'm just trying to figure out how you know that it was from him, other than if you're telling me it was his voice, I understand that. But I just wanted to clarify your statement that you believe that it was his phone.
Well, because you could push *67. Like, I don't, or download text apps, I guess. Like, I don't know. I would know it was him. So, but the one phone call I know was off of his phone. It was his phone number. It came up off of his number. And then another, so I don't know.
Okay.
I just know that I get phone calls from him that are not very nice.
Okay. Other than your testimony, ma'am, do you have any documentation or other evidence of the phone calls as far as anything, messages on your phone, any confirmation from your phone bills as the calls from him, anything like that?
I had emailed the court some videos that were sent to me, but yes, you didn't get those.
Okay, I didn't hear most of that, so ma'am, what happens, you're not coming through very loudly, so we're having to strain to hear what you're saying. All I'm saying is project. If you have to shout, do it so that we can hear.
I said I had emailed the court some videos, but I guess you didn't get those. I don't know.
We have no videos, ma'am.
Yeah, I had sent in that what evidence I had to the email that said to send it in. So I sent in that evidence.
Anything else, ma'am, that you have? Again, anything from your phone bill showing calls from the respondent or anything of that nature?
No, I don't. You can't get things off of Facebook and stuff like that. So no.
Okay.
I do have one additional question from.
Okay, go ahead.
Thank you. Ma'am, what's your phone number? Is that the same number you would have had in February and March?
Well, I have a couple different numbers. I can't tell you, but I've got a few different cell phones for my kids too.
Okay, so which phone was he calling allegedly?
It's called my son's phone and my phone.
What's your son's phone number?
I don't know it offhand. Like I said, I got them stored in my phone, so I don't know them offhand. I have to look at my phone. Like I store the numbers in my phone as the names, and I don't know the numbers. I know my phone number and pretty much 911, but I don't know numbers like that, cell phone numbers.
So you haven't replaced your phone yet?
Yes, I just replaced it the other day. I had to go to Best Buy, but it took a couple weeks because I had to have an appointment. So it was broke.
Okay, so were your contacts transferred?
Yep, my contacts were transferred.
Okay, so since your contacts have been transferred, can you tell me what your son's phone number is? 5?
Yep.
Okay, I have no further questions. Thank you.
Okay. Ms. McKediak, just to clarify, is there any other evidence, any other testimony that you have to present?
Oh, I think he made that also a statement when we did the first court date saying how, I don't know, I think, but that after the PPO was filed, he had said something about how that phone call back in January was made. And because that he tried to use that as him filing for his PPO, that phone call. So I don't know, I guess that's all I want to say.
Okay, thank you. Ms. Huffman, any evidence that you have to present, testimony otherwise?
I would just call Mr. McKediak.
Okay, Mr. McKediak, we'll have you raise your right hand, be sworn in, then we'll proceed.
Sir, do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes, sir.
Go ahead.
Thank you, Mr. McKediak. Did you make any phone calls to
No.
Lindsay McKediak in?
No, you have all my documentation, my PDFs from Verizon.
Hang on. Let me ask you the questions.
Okay.
Did you make any phone calls to Miss McKediak on January 27th?
No.
Did you make any phone calls to Miss McKediak on February 7th?
No.
And February 11th?
Oh.
Or March 18th?
No.
Did you make calls to her from any phone other than yours?
No. I
Did
didn't
you
make calls to her from my phone or
Okay.
any other.
And were you in contact with her via Facebook?
No. She has blocked off all my social media.
You have her blocked?
Yes.
And how long have you had her blocked?
Probably since at least before December of last year of 2023.
Were you in Florida on February 11th?
No.
And where were you on January 27th?
Michigan. Home. Or I might have been on the 27th. I might have actually been on the road going to Florida. Because I want to say I turned in the rental receipts to you. And I think I was back by the 5th or 6th. I'd have to go through my pictures.
Okay, could I share screen, Your Honor?
Yes, go ahead.
Thank you. Bear with me. It's the first time I've ever done this. Not sure exactly what I'm looking for. Oh, this. Do you recognize this picture?
Yes.
And what is this picture?
I think it looks like of one of the bridges in Florida. And that would have been, I don't know. They're time stamped. So there's dates and times on the top of them.
So if this one says February 2nd at 11:06 a.m., would that be correct?
Yes. February 2nd, that would be on my way home.
Okay. And then this one is January 28th at 4:15 p.m.
Okay, that'd have been on my way there because I was only down there for like 3 or 4 days, maybe 5 days tops.
Okay, and so if you went down there on January 28th, if you were in Florida on January 28th, would you have left to go there on the 28th, or would you have left the day before and spent the night?
Would have left the day before because we were driving. What's
Okay.
Florida? 12-hour one way or more?
So you left on January 27th?
Yeah, I had to because we left. Yeah, I'm pretty
Okay.
sure that was.
And then I don't know how to find my desktop. I'm sorry. I guess I don't know how to find my desktop. And I don't know what's loading, so hang on one second. Okay, so if I had phone records here, would any of these phone records show that you have made any calls on January 27th from your phone to any of Miss McKediak's lines that she stated today?
Yes, the phone records are from Verizon Mobile. They're the PDF of the bill of every month. They show what time, where I'm at, where I'm calling to, and what number.
Right, I'm asking you, would any of them show that
No,
you called her at any of those 3 numbers that she gave us?
no, that's why I had them all printed off and turned into you.
Okay, and I do have them all saved on my desktop. I'm just not sure how to load them.
Okay.
But I will figure it out if I need to. March 18th, did you give me records that show all of your phone calls on March 18th?
I'm pretty sure every month that was listed from the first court hearing was turned into you.
Okay, and if I were to look through these and not find any of these phone numbers that were given to me, would that surprise you?
No.
In fact, none of these phone numbers are going to be listed on here, are they?
No.
Okay. And so that was March 18th, February 7th. If it states that you started making calls at 4:04 p.m. and you ended making calls at 7:16 p.m., would that be accurate?
No.
If that's what it says on here, would it be accurate?
What? Oh, yeah, on the PDFs? Yeah,
Yes.
the PDFs are from the Verizon company. You can't alter them. You can't change them. That's
Okay.
your printouts, pay your bill. Those are exact usages of my phone, where I was, where I'm at, and who I'm calling, and what times, and how long the calls were.
Okay, so listen to my question. On February 7th, if it indicates that at 4:04 p.m. you started making calls and you stopped making calls at 7:16 p.m., would that be accurate?
Yes.
Okay, and that none of those calls on here would have been from or to any of these 3 phone numbers.
Correct.
Okay. And the same with February 11th. Nothing on February 11th is going to show that you made any calls to Miss McKediak, is it?
Nope.
Miss McKediak indicated that you contacted her on February 11th and that you FaceTimed her on February 11th and you were in Florida. Is that true?
No.
And by that date, you had already rented a vehicle in Michigan, is that correct?
Yes.
And if it says that you rented a vehicle on 2/5/2024 and you returned your vehicle at 2/24/2024 from Kalamazoo Battle Creek International, it looks like AP. Would that be correct?
Correct.
So if you were in Michigan renting a car, you would not have been in Florida. Isn't that correct?
That's correct.
Have you ever, either on your phone or anyone else's phone, indicated to Miss McKediak that you wanted to kill her or have someone else kill her?
Absolutely not.
And did you ever state that you would pour acid all over her so that no one else would ever want her?
No.
Do you have any reason to have contact with Miss McKediak?
Absolutely not. We're going through a divorce and I have a PPO on her and she has one on me.
Is there anything else you would like the court to know?
I mean, I apologize for their time being wasted today with these proceedings. You can read through the statements, see all the inconsistencies and everything, and we'll have to be doing it again because she's been contacting me violating her PPO.
Anything else, Ms. Huffman?
No, I would like to just make an offer of proof that I do have these.
Well, I'm not gonna take an offer of proof. What I'm gonna do is, if we're gonna have to do that and you can't submit them through the Zoom, which I guess, Ms. Hoffman, I only admonish you in this matter. If you're gonna submit something like that, you need to prepare to be able to do that. And the court's always available if somebody wants to call and check to see that the equipment works and their equipment works, et cetera. And so I'm not going to take an offer of proof when you aren't able to submit those and you could have done that. Anything else, Ms. Huffman?
No, I have nothing further. Thank you.
Ms. McKediak, you have a right to cross-examine Mr. McKediak if you wish to do so. Do you have any cross-examination?
I just want to say you can rent a vehicle in Michigan and then go to Florida, and that is what he did. I mean, there was a
Ma'am, is this a question?
I guess is there does she have the receipts of when he rented the vehicle and where he returned it at? Is that
I have no idea.
Is that because he definitely called me and from Florida and stated that he was in Florida?
Okay,
so
that's not a question, ma'am. If you have a question for Mr. McKediak, you can ask your questions now.
what? Oh. I have any questions for him. I mean,
that's what I was asking. Okay. Well, what I'm going to do in this matter, and I'm not going to penalize Mr. McKediak because, go ahead.
I was able to pull up the Hertz. I have those up right now, the rental receipts. They indicate that he rented the, sorry.
Okay, what I'm going to do, because you can't get the other, and I think it is germane and important, and I don't want to penalize Mr. McKediak because Miss Huffman is not computer literate in this matter. So what I'm going to do is we're going to adjourn this matter to next Monday at 11 o'clock. I will have Miss Huffman make paper copies and submit all those proposed exhibits to the court in paper and send copies to Miss McKediak as well.
Miss McKediak, would it be okay if I email those to you, or would you rather them be in mail?
Yeah, that's fine. But I mean, I know what happened, so I don't need them.
Well, ma'am, they're going to be, she's going to, I presume, offer those as exhibits. you should have the exhibits. So if she's offering to send those, you can decline that, but it's up to you.
Yeah, I mean, I don't. Why would I need them? I know he called me.
Ma'am, do you want them or not?
No.
Okay, thank you. Ms. Huffman, get those to the court though, so that we have those.
I will do that, and I do apologize. I'm sorry.
Okay, we will adjourn until next week at 11 o'clock a.m.
Thank you.
Two cases, 2024 113 PP, Lindsay McKediak versus John McKediak, and 2024 391 PP, John McKediak versus Lindsay McKediak. In the first case, 113 PP, Attorney Huffman represents the respondent.
Good morning to all of you.
Good morning.
Good morning.
Court notes this matter is a continuation of the hearing commenced on June 10, 2024, in which testimony was taken from both of the parties at that particular time, and that we needed to acquire some of the exhibits that Ms. Huffman was not able to provide at that time. Those have been provided to the court. I will note that we do have the phone records from Verizon on the respondent's account for the month of January and February in this matter, but those were the only ones that I received. Ms. Huffman, were there any other that I was supposed to receive that I didn't receive?
I do believe there should have been an April 20, the last, sorry, I'm sorry, hang on one second. April, I'm sorry. March, the one in March, I do have that available to share. I believe that would be the only one the court should be missing. All the rest should be available to the court. And then we did have, I did provide a copy of the proof of service to the court. I believe Mr. McKediak had a witness that he wanted to provide for that, but I'm not sure if he has that witness available.
Okay. Well, last week was the time and place set for those particular witnesses.
I have nobody in the waiting room.
There's
right now.
no one in the waiting room, so there's no one to present, even if you wanted to at this time. Ms.
Okay.
Hoffman, why don't you do the share the screen, and we can look at the March, because that is the only one that I'm missing. Yeah, right there. Okay, great.
Yeah, that should look a little bit better.
Okay. I'll ask the petitioner, Ms. McKediak, can you see that list of calls?
No, I cannot see it.
She's via telephone.
Oh, okay.
Can't see.
I'm going down there because I can't see it. McKediak, I've got a number of calls, probably about 10 to 12 calls on March 18. Give me, just give me the first 6 digits of your phone number with the area code, because I don't want you to have to disclose your entire phone number. What is your area code, ma'am? Okay, so, and what are the next 3 digits?
Yes,
Okay,
but I would like to just mention something.
if I can.
Yep, we'll give you time in just a minute. I was just checking out the list.
That's fine.
Okay, Ms. Huffman, if you want, you can take that down. I've had a chance to review that.
Your Honor, if I could just add that there, I believe, is a color photograph that we did present to the court that shows a car accident. It could be one in black and white, but it's a photo of across a guardrail, sorry. And then there's a wrecked car on the other side of that.
Okay.
Um,
And what's the purpose of that?
That is my client's vehicle in Florida when it was wrecked in Florida, which is why he got the, and then there was a person that died in that accident. And my client had to get a rental car when he got back. And the only reason I'm provided that is because, the petitioner indicated that the only reason my client would have rented a vehicle during the time in which we showed the court that there was a rental receipt, would have been to drive the vehicle to Florida. That proves my client that was his vehicle that was wrecked, and the reason why my client had to rent a vehicle when he returned back to Michigan.
Ms. Huffman, are you offering the, again, the picture and the phone records as exhibits in this matter?
I am. So the January, February, and March could be admitted as one exhibit A or one, however the court wishes. And then the pictures could be admitted as another exhibit.
Okay. We'll do that as exhibit 1 and exhibit 2. Okay. Anything else, Ms. Huffman?
I don't believe so. Thank you.
Okay. Ms. McKediak, anything else that you have?
I just like to say that, phone, calls are done, and I via Wi-Fi. All that.
Okay,
And
ma'am,
that
you're coming through. You're all jarbled, so I can't hear very well.
No, I'm sorry. Honey, okay, I'm sorry. The phone calls via Wi-Fi are not showing on here.
Okay, first of all, you're jarbled, and we've got a child screaming in the background. So,
Nothing further.
ma'am, why don't we do this? Why don't you disconnect and then reconnect? Maybe we can hear you better.
What's that?
Ma'am, end the call and then reconnect. And then we should be able, hopefully we can hear you better. No, she did. We had no problem hearing her last week.
That is.
Can you hear me?
Yes, we can hear you, ma'am.
Okay, I'm so sorry about that.
That's all right.
My son, he's autistic, and I'm at a school, and so this is
Okay,
the
well,
way.
ma'am, first thing I want to ask is, in this matter, Ms. Huffman has offered exhibit 1 and exhibit 2 in this matter. Do you have any response to the offer?
Just that with the phone calls, that if he was to call like via Wi-Fi, because
Okay, ma'am, I'm just asking as it
show on a
relates,
phone bill.
ma'am, hold on. As it relates to any legal objection to the offer of those.
That it wouldn't show up on a phone record.
Oh, okay.
That it would not show his phone bill. Wi-Fi phone calls do not show up on a phone record.
Okay. we will address that.
App phone calls also do not show up on a phone record.
Okay. Anything else as it relates to that?
And I mean, other than, you know, his situation in Florida, I don't know what his situation in
Okay,
Florida
well, let's address,
was
I
or
want to address, hold on, I want to address the exhibits first. The court will admit, respondents exhibit 1 and 2 in this matter, there being no legitimate objection to those. With that, I guess, Ms. Huffman, you have nothing else, is that correct?
I have no further evidence. That's
Okay.
correct.
Okay, Ms. McKediak, anything else that you have in this matter?
just that I was contacted and told that he was in Florida. Now his situation
Objection.
of what
I'm
Florida,
gonna
I
object
don't
to
know.
that being hearsay.
Well, we've established he was in Florida, so that's, I guess, not a big issue. So go ahead, Ms. McKediak, anything else?
That is just what he had stated to me. I don't know what his situation was. It's during his phone call, he had stated that he was in Florida. So,
Okay.
I mean, that's all I know. I don't know his situation of what took place or when he left or when he got back. I don't know.
Okay.
That's wasn't discovered over the phone call.
Okay. Ms. McKediak, do you have any closing argument to make?
I mean, no, I guess not.
Okay.
No.
Ms. Huffman, any closing argument?
Yes, so I would just state that on February or for the February 11th incident, Miss McKediak several times stated that he was in Florida. She stated that it was FaceTime call, that she knew that he was in Florida. Just now she said that someone told her that he was in Florida. When she testified, she said he told her he was in Florida. I just objected to her as her stating that somebody told her that as hearsay. But she said that anyway, the court allowed it. So I'm just saying that's what she just said right now, is that someone told her. And her, if I could just give my argument without interruption.
Yeah, Ms. McKediak, do not interrupt.
Thank you. My client simply wants nothing to do with Miss McKediak. He wants to get his divorce over. If that hasn't ended yet, last I knew, I think it was still open. He just wants to be divorced, be done with her. He wants absolutely nothing to do with her. He's not contacting her. There's no proof that he's contacting her, even though she said for his January 27th call, that it came from his phone. Specifically, it says, I spoke to both of them and it was from his phone. I provided the phone records for January, February, and March. None of these, in fact, not just those days, but every day. And none of the days have any calls to either of her number or her son's number, which she stated he also called her son's number. Those numbers are not on any of his records. The records come directly from his phone company. They don't take numbers out to satisfy what Miss McKediak wants them to say. So again, I would just, there is significantly insufficient evidence to find violated any PPO. Thank you.
Okay, thank you. Again, anything else, Ms. McKediak, before the court gives you a ruling?
Just no, he'll just keep bothering me.
Okay, thank you.
Bothers me with different people and him. So.
Well, if there's other people that are bothering you, you can always get a PPO against them. Again, that doesn't pertain to respondent. As a result, the court is not going to address that. Specifically in the petition to show cause in this matter, the petitioner had alleged various dates on which things she said occurred. The first date was January 27, 2024. Second date, February 7, 2024. Then February 11, 2024, and then March 18, 2024. She also claims that, again, there was a FaceTime call. I think that was the February 11, 2024 date. In this matter, the court has looked at the Exhibit 1 and looked at those particular records. The records show on the January 27th, 2024 date that she claims, and she delineated what the call was, etc. And the court will note that on his phone records, it does not show any calls from his phone to the 269-268 number, which she identifies as her number. Further, in this matter, that is the January 27th date, the February 9, 2024 date in which she delineated a call to her. That looking at the records, there was no call from his phone on that date. On the 2/11/2024, the date of the alleged FaceTime call, that in fact there was no FaceTime call on that. Plus, the testimony of the respondent was that in December 2023, that plaintiff had blocked him from all social media contact to him. Further, on March 18, 2024, which we saw today, there was no call to the plaintiff on that date from his phone call or from his phone number. Taking all of that into consideration in this matter, it does amount to more than a he said, she said, as he has provided documentation and evidence to show that he did not contact her. And as a result, the court will deny the show cause and deny any finding of contempt in this matter. The court will next go to the respondent's motion to terminate. He alleges that he did not do any of the things as alleged. Court will note that credibility is always a consideration in every case, and especially these types of cases. Oftentimes, a party will allege that the other party or one of their witnesses is not truthful or lying. The court has found that inconsistency in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding or misunderstanding or mistake. And when consistencies occur, the court will attempt to determine if they can be reconciled by other testimony or evidence. In this case, we have diametrically opposed testimony, so the court has to look at other evidence, and that other evidence is the exhibits that were submitted in this matter that shows that the respondent, Mr. McKediak, has not contacted her in this matter. And so that evidence presented goes to, again, more than simply a he said, she said, but is backed up by other objective evidence to substantiate that, again, there was not contact. I'm not saying that there's not anything that's alleged to have happened in this particular matter, but it does, again, go to the issue of credibility when we have someone making various statements and then that testimony being, again, refuted by objective evidence in this matter. As a result, based upon that, the court will grant the respondent's motion to terminate the petitioner's PPO in this matter. And I would simply caution both the parties, don't communicate with each other, don't contact each other. And in your case, Mr. McKediak, even though the court has terminated that, I'll let you know that the court could at some future point grant a new PPO if the circumstances warranted that. You understand that, sir?
Yes, sir.
Okay. Okay, that will be the order of the court, or the orders of the court in this matter. And we'll conclude this case. You're free to go. Have a good day.
Thank you.
Thank you so much.
Thank you. Have a good day.